Did you know turning down the wrong tenant the wrong way can cost a landlord several $1,000s for a single applicant? Not over the rejection itself, but over one piece of paper most people who screen their own rentals have never even heard of. So, for example, let's take Brian. Brian owns 6 rental units and he's careful. He runs a credit and a background check on every applicant. None of this renting on a handshake stuff. Well, last spring he had 2 solid applicants for the same unit, similar income, both employed. So he went with the one who had the higher credit score. And that's reasonable, right? That's what a lot of landlords would do. That's what you're screening for. Well, 3 weeks later, Brian gets a letter, not from the applicant he turned down, but from the applicant's attorney. And the claim wasn't that he was discriminated against or that he picked the wrong tenant. It was that the second that he chose one applicant over another based on that credit score, the law required him to hand the tenant, the specific tenant, a specific notice, and he never did. You see, he didn't even know that it existed. And that's a trap almost every landlord I talk to right now is standing in. And at the end, I'll show you the bigger exposure that even from a perfect paperwork standpoint, you can't be protected from. Okay, let's get started. So let me back up here. You see, the law is the Fair Credit Reporting Act, or the FCRA. You know it is the law about credit reports. You see, when most landlords don't realize is the second you pull a tenant screening report, credit, background, eviction history, you become what the FCRA calls a user of consumer report, and users have legal duties. That's duty that trips people up is something called adverse action. And here's the definition most landlords carry in their heads. Adverse action means I deny the applicant flat out, no rejection. That definition's wrong. In fact, it's one my father has told me he understood it to be, and it's the most expensive misunderstanding in residential real estate. You see, under the FCRA, an adverse action is any decision unfavorable to the applicant that's based even partly on what you found in that report, not just a denial. You see, the rule I teach is simple. Anything other than an unconditional yes can be an adverse action. Hey, I'm an attorney. What do you expect? So let me show you how little it takes. Go back to Brian. All right, 2 applicants, similar income. He picks the one with the highest credit score. Okay, as we stated, that makes sense. You see, that decision was based on the report, and it's unfavorable, the law says, to the person he turned down. Adverse action. So you do approve someone, but because their credit was shaky, you tell them all rent has to be paid in certified funds. Okay, so in that case, you see they got a problem with their credit report, and you then change how you're going to get paid by that tenant. Okay, so you said yes, but it doesn't matter. You see, now you condition the lease on something you found in the report. Adverse action. So you have to be very careful here when you're pulling reports and how you talk to the people that you even decide to rent to. Or is this one is my favorite because it feels so harmless. So understand this, a self-employed applicant hands you their W-2s, and because of something in the file, you ask for a tax return on top of it. Of course, just covering ourselves. Well, that extra ask triggered by the report, adverse action. Cosigner, bigger deposit, higher rent, certified funds, one extra document. Every one of those can trigger the same legal duty as a flat denial. And I see this a lot when it comes to having people co-sign on rental applications. That is a huge problem that landlords are not aware of if it's triggered by something they see on the report. Now, here's a wrinkle that catches people. If you deny the main applicant, that denial is also adverse to their co-signer. So it can be a second notice you owe to a second person. So the universe of things that count is enormous. The question is, what does the law actually make you do about it? You see, when you take an adverse action based upon a consumer report, the FCRA requires you to give the applicant an adverse action notice. You see, it's a specific letter, and it has to contain 4 things. Okay, number 1, notice that you took the action. You're telling them in writing or even orally that the answer was tied to your report. Number 2, if you used a credit score, the score itself and the key factors behind it. Number 3, the name, address, and phone number of the screening company that gave you the report, plus a line making clear that company didn't make the decision and can't tell them why. Number 4, a statement of their rights. Okay, everyone always has to get a statement of their rights. It's crazy that they can get a free copy of the report and they can then dispute anything that's wrong with it. And the thing is, if you miss one of these four, okay, or you fill it out sloppy and the notice is defective, which in the eyes of the law can be the same as never sending it at all. And that's what attorneys love to pounce upon when landlords make these mistakes, because it's free money for the attorney. So timing, this is where I see a lot of bad information online. So you have to be precise here. If your decision is based on the consumer report itself, the statute doesn't hand you a specific deadline. But no deadline is not a license to sit on it. You see, the standard is what we refer to in the law as reasonably prompt, or within a reasonable period of time. And what that means is that if you're a smart operator, I would send it right away. Now, there's a separate situation. Say you didn't rely on the report. You called the applicant's old landlord and the landlord told you something that sank the deal for this person. That's third-party information, not a consumer report. Well, different rule. There, the applicant has to ask you in writing within 60 days, and then you disclose the nature of what you heard within a reasonable period of time. Now listen, you don't have to memorize any of this, okay? Or the subsections. Worry about the principle here. That's what I want to get across in this video. You see, the moment you do anything other than say an unconditional yes, assume a notice is owed and send it. And there's no penalty for sending a notice even if you didn't owe them a notice. The penalty is only run the other way, when you don't provide it and you had to. Okay, now what happens if you don't do this? So let's talk about that. What actually happens to Brian? Well, the FCRA splits out violations into two buckets, all right? If the failure was negligent, you just didn't know, honest mistake, the law says you're on the hook for the applicant's actual damages plus their attorney's fees and court costs. So this is what I alluded to earlier. Attorneys troll for this stuff because it's free money for them, okay? Now there's one that I really want you to hear because the internet gets it wrong constantly. If the failure was willful, and willful in this law doesn't mean you were malicious, right? It includes reckless disregard, which is a pretty low bar, and a different section kicks in. Under it, the applicant can recover either their actual damages or statutory damages between $100 and $1,000. So read that again. Statutory damages. That means the applicant doesn't have to prove they lost a single dollar. They're just entitled to the money. They don't have to show anything here in order to get that. You see, the damages are baked into the statute. So on top of that, the court can add punitive damages if they determine that you're maliciously acting that way, plus your attorney's fees. They're already added in. On top of that, if they show a pattern of behavior, you could see this starts to ratchet up on you because they want to send a message to you. So, and every applicant you took an adverse action against is a separate count. So that's the problem. If they find other people, and this is what I've seen happen before, attorneys then will try to get your applicants that they've applied to your building to rent property from you, and they'll go through that. And then they'll say, all right, we're going to reach out to all those to see if they were affected the same way. So one bad week of screening, 4 applicants, 4 missing notices, and you can see how a paperwork slip becomes a real number really quick. And this is exactly why, as I stated, all these attorneys across the country that operate in this space, they see this great fee shifting opportunity for you to pay them. All right, it's what makes the attorney's time worth looking for these missing one-page letters. So the exposure is real, and it's federal, and it's almost entirely self-inflicted every time I come across this. Now the good news is that the same statute that creates the trap for most of us who are landlords that were unaware of it also hand you a way out. Now this is the part that I think is really important, and again, no one's going to tell you this unless you're watching videos like mine. It's that the most important sentence in the whole law is for an operator. You see, the FCRA says you're not liable even if a notice was wrong or missing. If you can show by preponderance of the evidence that you maintained a reasonable procedure to assure compliance. Okay, so in plain English, what does that mean? That the law doesn't demand perfection, right? It just demands a system. So if you have a repeatable process for handling adverse action and you can prove it, and a one-off mistake then doesn't automatically sink you. That's your shield. So you have to show, hey, this is what I normally do. Yeah, maybe I missed it this one time, but I have a system set up to notify people when there's an adverse action. So what does reasonable procedures look like? Well, this is the framework I teach. It starts with a one decision rule for your whole operation. Any answer that isn't unconditional yes triggers a notice automatically every time you send it out. You could probably set it up in AI to do this, so there's no judgment call in the moment. You take discretion out of it. So as a busy, say you have a busy leasing day where you see 5 or 6 people coming to look at your units, all right, that's it. It's really simple. It'll just happen for you. Then you use a compliant form for every one of those notices. And here's something most landlords don't know. You see, the Federal Consumer Financial Protection Bureau, so much to say there, publish sample notices forms that you can build from. All right, they're free, they're available to you. They were written primarily for a sister law, so they're not plug and play for the FCRA exactly. All right, you have to make sure all 4 elements we covered here on this video are actually in there. But if you use them correctly, leaning on these forms is one of the cleanest ways to show that you are trying to comply, because the federal government actually puts out these forms. You just need to modify them. Now, the part where most people get hurt isn't the form itself, it's using it wrong. So, checking a reason that doesn't apply, forgetting to check a reason that does, sending it late, a form filled out carelessly can be worse than, of course, no system at all, because now you've documented your own mistake, and that's where you have to be super careful. So building the actual procedure, triggering the rule, the right form, the documentation that proves the system existed, that's where the work is, and it's worth doing properly with someone who does it for a living, all right? So what I would advise you to do, okay, maybe you reach out to a local attorney who is a landlord attorney and ask them to walk you through the process and help you create your system and your forms around it, because you do not want this exposure, all right? So here's the thing about Brian. Let's say he fixes all this, perfect notices every time. He's now protected from that specific lawsuit, but he's not protected from the next one, okay? Think about who actually sues over a missing one-page letter, right? It's the applicant who's looking, right? The one who reads every line, who knows the fee-shifting math, who treats the paperwork slip as a payday. Now, imagine that same person doesn't get turned down and you actually rent to this person. They move in, and then 8 months later, there's a slip and fall on the stairs, or a fight over the deposit, or a habitability claim. You see, a perfect adverse action notice does nothing to protect you from the problem tenant. So if Brian owns his building in his own name, or all stacked multiple properties into one LLC, then a single bad outcome reaches everything he owns. You see, the compliance letter was, I'm going to call it hygiene, right? It was never asset protection. It's just to save you from getting attorneys coming after you where they know they can shake you down for money and you have no defense, unless you can show, like I did, was a one-off and you have a system in place. But my greater concern is the litigious applicant who taught Brian that lesson, previewing your tenant, okay, is actually going to go a long ways to protecting yourself. And if you do hire or bring in the wrong tenant, then it's going to test potentially your structure. This is the conversation I'd rather be having with you, right? Not talking about tenant letters. Did you send it? Did you not send it? Okay, I want to know whether or not you've set up a plan to protect yourself. Okay, so for most landlords, the honest answer when it comes to asset protection, unfortunately, is they haven't done anything yet. And they don't find out until it's too late. You see, the framework I use puts real separation in place. You've watched my other videos. If not, go to you're on my channel, go to those other videos and just start watching them about using limited liability companies, creating an asset protection stack, using Wyoming LLCs as a holding company for charging order protections, and splitting out your properties one property per LLC. You see, that's a system. That's a system that's repeatable, and it's a system that will protect your portfolio. So here's what I would do if I were you. 2 moves, very simple. First, today, assume every answer that isn't an unconditional yes is owed a notice and put a real system behind it. That alone will put you ahead of where most landlords are in the country. Second, have someone actually look at how you hold these properties. If your rentals are in your own name or bunched together in a single limited liability company, you've got the same gap Brian had. You just haven't met the right tenant yet who's going to find out about it and end up trying to take him from you. Listen, my team at Anderson Business Advisors, okay, we can help you creating the number two, or solving for number 2. We look at your portfolio, you figure out where your real exposure is, help you create a system that will protect your assets. Now, there's a link below in the show notes that allows you to set up a free strategy session. I would encourage you to take advantage of that right now. Doesn't cost any time. We'll look at your structure, give you a complete overview of what you should be doing today, analyze where you want to go tomorrow. And not only will we look at it from a asset protection standpoint, we'll also look at it with tax savings in mind. Hey, and if you want to see me live in person at one of my events, be sure to check out our website, Anderson Business Advisors, and look for our next event where I'll be speaking at 3-day in-person event where I go through all these types of strategies that I share with you on my YouTube channel. Everyone that goes to this event walks away saying how phenomenal it was. I hope to see you at that next event. Take care.